State of Texas versus Gracie Sugundo. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Bureau Levi, Daddy Bellas.
Are you Gracie Sugundo?
Yes, ma'am.
All right. According to the plea bargain agreement, punishment is to be assessed at 7 years in the prison. There's a $500 fine. State is opposing your application for deferred adjudication. They're recommending community supervision, and there are items to be taken in consideration. Have both parties had a chance to review the PSI report?
Yes.
Any objections to the PSI report, state or defense?
Judge, so there are some errors on the PSI report we wanted to bring to your attention.
Yes.
So at least the offense date has, I believe, November 15th of 2021, when in reality the offense date is on the indictment is 2021.
All right.
And it lists that in the criminal history. There's an assault within the criminal history that it makes it seem as if two separate offense dates.
Okay.
And then I think in the towards the back of the actual statement itself that Mr. Bruno gave, there's a portion where it's talking about the co-defendant and that he's charged with ag assault deadly weapon. Assault, yeah, it's the same offense.
Okay.
We just wanted to make sure you were.
All right. And the court is also in receipt victim impact statement, and the court reviewed that without objections from the state or defense. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
And the court is also in receipt of letters that defense presented on behalf of the accused, and there were no objections to the court reading those letters. Is that correct?
This moment right here is huge. When defense challenges details in the PSI, it's not nitpicking. Accuracy in the PSI can decide whether Gracie walks out on probation or ends up with a felony conviction. These corrections set the tone for everything that follows.
State and defense?
Okay.
All right, so the court has reviewed all of those documents.
All right. Also, as part of the agreement coming back today, which is it needs to be put on the same day as this alleged date. To take into consideration County Court 4 case 93701.
Yes, and the court does have that as a part of the plea bargain.
Judge, just to kind of explain all that, I believe that's an additional part of the agreement was that she was to take responsibility for what happened. That's part of it, yes.
Yes. Okay. All right. So my understanding, the complainant in this case is Rebecca Martinez. All right, and is that Rebecca Martinez who's on the fourth court? All right. So that everybody can be aware, I do know Rebecca Martinez. She's never been to dinner at my house. I've never been to dinner at her house, but I do know her. We are colleagues, and when I see her, I say hello. She says hello to me. I may ask her about her day. She may ask me about my day. But I will tell you that my decision on this case is not going to be impacted by the fact that I know her. So if anyone has any objections to me hearing this.
Pause. This is the tense part. The judge admits he personally knows the complainant, who also happens to be Judge Rebecca Martinez. In most courtrooms, this could trigger concerns about bias. But watch how he handles it. He puts the issue on record and invites objections to protect the integrity of the process.
Now is the time to say so. State?
No.
Okay.
No, I have all the confidence. You're right. So no objection.
All right. So are there any witnesses that anyone wishes to present? State?
State doesn't have any witnesses. The main thing that we wanted to court over was the statement from the complainant. Which was the court has already made.
Defense, any witnesses?
Other than Mark and our chief for considering this matter, I will be speaking in this and I see a couple of words. Your present and supportive for today. The same is supportive for today.
All right. Thank you.
We will not be.
Right. So before I begin with your presentation, with regards to the case to be taken in consideration, if you could raise your right hand, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand, state your name for the record.
Gracie Sugundo.
All right. And with regards to County Court Cause number 693-701, state is taking that case into consideration, but to that case, how do you plead? Okay. That's okay. So, in order for me to take that into consideration, she will have to accept full responsibility for it. So, a no contest plea, I can't accept that because I don't have any police reports in regards to that. So, she will have to enter a plea of guilty to it and accept responsibility for it. And then the state will tender dismissal to the court, and the court will sign that. I don't know if you want to discuss that with her.
We'll go ahead and proceed with a guilty plea now.
All right. So the county court cause number 6933701. How do you plead to that? All right. And state, do you have the dismissal for the court in that cause number?
This is where the stakes skyrocket. The prosecution isn't just saying no, they're painting a picture of a life-altering injury caused by the assault. When a victim claims long-term impact, judges often lean toward harsher outcomes. Listen closely to how the state frames this as senseless. That word alone carries weight.
So the court then will hear argument. State, you're opposed to deferred adjudication?
Yes, Your Honor. The reason why the state is opposed is because of the nature of the offense, the actual underlying facts. There was an assault that occurred where the resulting assault it created a lot of issues for the complainant. She was severely injured. Her life was severely impacted from that day forward, and she still feels an impact to this day. It's something that was senseless. Didn't need to happen in the first place. So that's why the state is opposing deferred and is probation.
Defense?
We're here because one incident can't define a person unless they're alive. And this is very serious, and no doubt that we take that very serious. This is a felony charge. It's a felony charge that brings a very significant penalty. But this Sugundo, I think, has demonstrated a respect not only to others, but to life, to animals, and her work and her proof, and taking care of pets. But rarely do I have an opportunity to where a client can provide 32 letters of reference about how wonderful she is caring for others. And that is the life that she defines herself with. We just feel like this should not define her as a felon for the rest of her life when she has 4 children as a single mother. We know that life is difficult and it's very, very, very hard. And she's having to raise 4 children on her own. 15, 14, 12, and 10. As a single mother, she has to be involved in school activities and support their activities. And a felon cannot be associated with children and be around them in school activities. This will drastically impair her ability to be a mother to her children. So she's really fighting to be able to continue to provide the love and the support for children that need their mother so that they can become better than her and have a future. She lives in Houston. She uses a home. She's lived in her home for 3 years. She has good family support. As I said, her mother and father are present. She has a high school diploma. She has been employed during this whole time. This case is 2 years old. 2 years. This week. It's been 2 years that she has been experiencing this, and she has complied with everything this court has asked. She's appeared in court. She's traveled to San Antonio. She's fully cooperated. She has weighed all of her decisions, sought not to seek trial, but to put a decision on deciding her future. And she made that decision because she felt that was in her best interest. She does receive some child support. She is willing to do everything and anything it takes to give her this opportunity. I explained to her that deferred adjudication is a double-edged sword. You may think that, okay, you're not going to be subject to a conviction, but in actuality, you are subject to all the conditions of behavior for 7 years. We're asking you, Judge, to give her that chance, to give her the opportunity to prove to you that this one incident does not define her life, who she is, or how she is as a mother, or how she works. This case was very regrettable, and it should have been a day of celebration. It was after a football game, and she was acting in...
This is classic courtroom persuasion. The defense turns the spotlight from the crime to the person. Character letters, single mother hardships, employment history, all designed to humanize Gracie and convince the judge this was a one-time mistake, not a pattern. The emotional punch? The fear of being labeled a felon forever.
Defense of another. She doesn't know the victim in this case. She doesn't know the judge. She never knew who she was. And I sincerely believe that just because she's the judge doesn't mean that this case is any different than any other case, any other person who comes to this court and gets justice, because she should get an opportunity to do it. She's willing to do the urine analysis. She's willing to state no contract, and she's had no issues in the last 2 years with the complainant in this case. She's willing to take over management classes. She's willing to do community service. She's willing to do what it takes to give her a chance. And she has proven, other than this one incident that happened in a flash, wasn't premeditated, it wasn't thought of, it was just something in the reaction and defense of someone that she was with. So for that reason, we think that she should be given an opportunity to the right to get going. The amount of restitution this is that is presented before the court is $2,416.29. We fully agreed on the pay that. We will work hard every day to pay that. But in this working community in Houston and San Antonio, mothers every day have challenges. We regret that this happened, and I know that you sincerely I have nothing personal against Ms. Martinez or her husband. She wants to do what's right, and she also wants a chance, Jonas. And I'm asking you, with all the fiber of my body, to give her that chance. And I will make sure and work with her that she will comply with every condition, so she will never be back here before you regarding any violation or any condition in this case. No one's just.
All right. Well, just so you know, in this court, I see everybody as a human being. I don't see them as their titles. So, me, defendants are not defendants. They're human beings who are accused of a crime. The fact that Rebecca Martinez is a judge, that doesn't mean that I'm putting weight on the fact that she's a judge. If she were the president of the United States, and she were here as a complainant, I wouldn't put weight on the fact that she's the president of the United States. I'm just dealing with the facts here. And my job is to look at everything objectively and not outside noise, not what people's occupations are. You understand? So I always reread everything and reread police reports and PSI reports, and I've read the letters. I do not understand how the fact that an elevator has a limited capacity, how we go from people saying the elevator is full, you cannot be in an elevator to crawl. So explain that to me.
I couldn't say it.
I mean, there has to be some sort of thought process. For example, if there's an elevator, I think everybody knows there's a weight capacity on the elevator. Me personally, when I see there are too many people on the elevator, I don't get on. But obviously what we are here now for is there's an elevator. According to everything that I've read, the elevator was at capacity. And there were already some people on there. I don't understand how an elevator is at capacity. People need to get off or more people can't come on. How that ends up in a fight.
Here comes the moment that can make or break sentencing. The judge directly questions the logic behind the incident. When a judge says, I don't understand, that's your opportunity as a defendant to clarify clearly. Any hesitation or vague answers can hurt credibility.
I couldn't tell you how it happened. You know, somebody in my party was getting into it. Somebody hit me and I just reacted. And unfortunately, I feel bad. And should never have done that. Shouldn't have got to that. We just have to, you know.
I know things happen quickly, but the police report I'm reading, it doesn't say that somebody in your party got in an altercation and you got hit and so therefore you got into a fight. What your counsel is telling me is that somebody in your party, I guess, was in a fight, then you decided to get involved in that fight.
You know, I went to go and try and pull my my front way, and then with it, I don't know, it was just a bunch of people. The lady hit me, and I just reacted.
Your Honor, if I could clarify, I think the fact is this is a COVID era situation in the elevator. These elevators can accommodate 18, 20, 22 people, and they're limiting it to 7. Whereas people went in the elevator, policy and procedures that the elevator operator is now allowing people to come in once they look at capacity. They were in the elevator, there was too many in the elevator, and then people had to decide who was getting off, and they asked who she was with, another man and another person to get off the elevator. That person said, I want to talk to your supervisor. That individual also the victim's husband got spilled out of the elevator onto the floor. She came in assistance to that man, and that's when she was hit, and that's when she struck. That's one of the reports here that was provided to you in the PSI. She did not go in there to fight. She didn't go in there to look for someone to fight. She was trying to get someone off her rent. And the process of that was struck. She struck and she injured her hands. And so, regrettable, there's no doubt about that. And this incident happened in a matter of seconds. And that's why we're here 2 years later doing that. And in addition to that, Judge, there is a civil suit in this case, where the parties in this case are seeking $1 million in damages against my client. And so, this case will not end today. It will continue in a civil matter in the lower court, where she will have to defend herself in a civil cause of action.
Judge, just to clarify from the state, and I would disagree with the characterization of how the incident started. The party was already on the elevator. They were asked to not enter the elevator. They weren't kicked off the elevator. They were asked not to. And that's what started.
I also have a copy of the lawsuit that was filed this week before this incident. We're seeking $1 million damages in civil lawsuit, right? You want to see the judge? It's public record.
I would object just relevance.
The lawsuit's been filed in the city court. That's a copy from the courthouse.
All right. Unless there are some facts that are listed in the lawsuit.
The whole case, John. That's what you're talking about. It's blood in the civil suit.
Plot twist. There's also a civil lawsuit seeking millions. That doesn't impact the criminal verdict directly, but it absolutely increases the emotional gravity. The judge shuts it down due to relevance, but the mere mention adds long-term consequences beyond today's ruling.
I mean, if that document has facts that somebody has, alleged facts that somebody has presented, that's a different rendition from what's in here, then the court will.
It doesn't, Judge.
All right. So,
just to let you know, there's a civil suit.
all right, then the objection will be sustained. All right. Anything else from either side?
No.
All right. I've read your letters that were presented. It appears that, other than this one incident, you're a great person. But sometimes sentencing, not sometimes, always sentencing has to do with punishment, rehabilitation, and basically whether or not someone should go to prison or not go to prison. These are all things I have to think about. You understand? And so I have to weigh certain things. And the things that I'm weighing are the fact that there were people in the elevator and you were asked not to get on the elevator. Is that correct or is that not correct?
We were on the elevator.
Yeah, the elevator door was open. You came into the elevator and then you're asking too many in the elevator. And the elevator asking folks voluntarily get off.
All right. So there were already people on the elevator. Then you got on the elevator and you were asked to get out? All right. Then you were asked to leave. All right. So why didn't you just get off the elevator? That's what I don't understand.
She didn't decide that. It was the person she was with, Your Honor. Ms. Bennett in the case, it's another court.
So my question is, though, if there are too many people on the elevator, and let's say you get on the elevator, it's a group of you, the elevator is already filled. I'm assuming, and correct me if I'm wrong, people were on the elevator, they had not met their 7-person capacity. And then you and your group come on, and because of the number in your group, they've exceeded their 7-person capacity. Then they're saying, you all need to get off the elevator and wait. Why not just get off the elevator?
This is sentencing philosophy in action. Punishment versus rehabilitation versus future risk. The judge is summarizing exactly what they're weighing, and the elevator decision becomes a central moral question. Why didn't you simply step off? Judges love simple logic. When that logic breaks, so does the defense narrative.